All right, guys, now it's time to talk about employment contracts. Fourth quarter is the best time the whole year to make restrictive covenants and tie them to some kind of a consideration. Why am I so excited to talk about employment contracts? As you level up in your business, and we talked about this before, you're going to get a lot of employees that will take over your company for you, which is a really great thing, right? But that's a double-edged sword. There are consequences to have an employee staff that can completely run your company without you. One good consequence is that the company doesn't depend on you. Okay, so if you get sick and you have to leave, or if you pass away, the company can be passed on to your heirs. If you have a trust, do you have a trust? Get a trust. Give us a call if you don't have a trust. Yeah. But it can be passed down to your heirs seamlessly with a trust, and then it can keep going. It can keep creating revenue as a true asset for your heirs and your family and your kids and everything like that. However, the flip side of this, the other side of this coin, is that if you have built a great staff and trained them and everything to run your company without you, that means that they can run your company without you. That means that they don't depend on you to run your company. And that means that if you don't have some kind of protective contract with them, they can steal your company legally. Your employees that are highly trained can steal your company. It's totally legal. And I hate to say it, but I've seen it happen numerous times. Here's what it looks like. One time, a client of ours purchased a business. This client did not want to put restrictive covenants onto the business's key staff. The business was about $2 million a year. It was a floral company. And what happened was the key employees that managed all of the major sales relationships with that company's customers didn't like the new owner. They decided to up and leave. And legally, they were able to take all of their customer relationships with them, all of their vendor relationships with them, and they just got a small loan to buy a bunch of inventory, and then they were able to set up shop literally down the street from the original company location. And of course they were major competitors, and that original company, which was sold to our client, had to cave because they had no value to that company. They had no clients, they had no customers, and they got it for free. So our client purchased this company for, a great deal of money, and the seller got paid a great deal of money. And the key employees and the staff were able to walk away with the entire company for free legally. Another good example, some dear friends of mine who about 10 or 15 years ago, we were not representing them, but they had built a division of their company. It was a whole separate wing, and they had key staff that did not have restrictive covenants on them that built this whole wing, and they demanded a exorbitant raise that was about triple what they were getting paid at any time prior. The raise was refused, reasonably so. And when the raise was refused, they decided to leave and take that entire wing of the company right when it got to be profitable. This can happen, and it was totally legal. You would think that that would be illegal, but it's not. It is only illegal if you put a restrictive covenant provision into their employee contracts. There's also a timing issue involved here. If you're going to put an employee on restrictive covenants, and what are we talking about here with restrictive covenants? We mean non-compete agreements, potentially, certainly a non-solicitation agreement, a non-disclosure agreement, non-disparagement agreement. These days, a lot of people will, send negative reviews, and they'll threaten people with that. So you want that as well. And a bunch of other non-provisions in there so that you can restrict them from taking over your company, essentially. The key to why this is important is that you need consideration. Consideration is just, you need to give them something to have them sign this new agreement effectively. Otherwise, they don't really need to, and legally speaking, if you're not giving them something more than you would otherwise give them normally, there's no consideration to this new contract, and the court doesn't have to hold them accountable to it, if that makes sense. So it's not necessarily enforceable against them unless you give them some consideration. Thankfully, there's one time just about every year for most companies where employees get a bonus or a raise or something like that, and it's around the holidays. So if you start to write your employment contracts with restrictive covenants, all the non-compete, non-solicitation, non-disparagement, non-disclosure, etc., you can hand them this proposed new contract for a Christmas bonus, a New Year bonus, or a raise, or what have you, whatever you think is reasonable. And then they have consideration for signing this. So that means that we'll be able to enforce it for you if, God forbid, that's ever a problem. Fourth quarter is the best time the whole year to make restrictive covenants and tie them to some kind of a consideration, some kind of a bonus or something around Christmas or January 1, depending on when you want to, put your taxes in for that amount. So guard your company. This is your greatest asset, likely, if you're an entrepreneur like me. And that means that you need to protect it. It's great that you have trained such a wonderful staff, but you do need to be smart and you need to protect it. So keep rocking, guys, and we'll talk to you soon.